Assalamu alaikum and welcome back to the Deep Dive. Today, we're tackling a huge constitutional puzzle. It's something that has really haunted every system of government from ancient times right up to today.
It's a fundamental question, really.
It is. How do you build a system of justice that's strong enough to command real authority, but at the same time, humble enough to admit when it's just wrong?
It's that core tension, isn't it?
Yeah.
The paradox of judicial power versus the simple fact of human error.
Exactly. And if a court makes a ruling, and then, later on it's found to be based on flawed evidence or a misreading of the law, what do you do?
What's the mechanism to fix that?
Hmm.
How do you correct that injustice without just destroying the judge's credibility or, worse, paralyzing the entire legal system?
We're not just looking at a simple procedure here. We're looking at the constitutional DNA of self-correction.
That's a great way to put it.
And to explore this, our guide is Mr. Zahir Ahmad Mir's fantastic work, The Foundation of Islamic Jurisprudence, Volume 1, Subvolume 3. We're diving deep into Case 15, which is all about the framework established by Hazrat Umar ibn al-Khattab, may God be pleased with him. And this goes way back to 16 AH, or 637 CE.
And to really appreciate what's happening in Case 15, you have to remember what he had already built. This wasn't happening in a vacuum.
Right.
This appeal system wasn't built on, a foundation of sand. It was really the capstone of a remarkably sophisticated judicial system.
We've covered this in other dives, but it's worth a quick recap because the context is so important.
It is.
He'd already established judicial independence. That was Case 9. He standardized procedures and protocols, which we saw in Case 12.
Right, creating consistency.
Yes.
Yeah.
And he enforced meticulous evidence discipline. What counted as evidence, how you present it, that was Case 13.
And critically, Case 14, the financial insulation for judges, protecting them from bribery or economic pressure.
So after doing all that, after making sure his judges were independent, financially secure, and had rigorous procedures to follow, he still knew something.
He still knew they were human.
Exactly.
And that's why this appeal system, the focus here, wasn't just some add-on. It was the final safeguard. It was the check on the judiciary itself. It was the system's admission that, despite all the safeguards, human fallibility could still creep in.
So that's our mission for this deep dive. We're going to unpack how Umar introduced this structured system of appeal and review, a system that had to balance two critical needs.
Error correction on one hand.
And preserving judicial dignity and institutional strength on the other. He was basically anticipating modern appellate courts by more than 1,000 years.
It shows that true authority, lasting authority, comes from accountability.
Not from pretending you're infallible.
Precisely. We're looking at how a judicial system becomes not just competent, but truly resilient, self-correcting, built to last.
All right. Let's start with the fundamental truth behind all of this, the premise that makes it necessary, the inevitability of error.
You have to start there.
If you look at any complex human system, right, medicine, engineering, law, the best ones are the ones that accept mistakes will happen and build in ways to catch them.
They build in quality control, review mechanisms.
Every judge is human, and so every judge can make a mistake. A legal system that tries to ignore that fact doesn't protect justice.
No, it protects ego.
It protects ego, and that's the whole game right there.
And that single realization that protecting a judge's ego is the opposite of protecting justice. That's where the genius of this system really lies. Umar wasn't just trying to fix a single bad verdict. He was trying to inoculate the entire institution against its own worst tendencies.
Which are what?
Stubbornness, a refusal to admit imperfection. That's what causes the internal decay.
It's funny, we often think authority means being right all the time. But if a court is treated as if it can't be wrong, the whole system just becomes rigid and toxic.
It does. The public can see the error.
Yeah.
The litigants know it. Even the judge might privately suspect it. But the structure itself won't allow for a correction.
And that gap between reality and procedure is, well, it's fatal for public trust.
That's right. And this brings us straight to the constitutional paradox he had to solve. The source makes this tension crystal clear. He saw two mutually destructive forces.
Okay, what were they?
On the one hand, if courts cannot correct themselves, they will inevitably collapse.
Why? Just because of public anger?
Partly, yes. But it's also because the errors build up. Uncorrected mistakes become bad precedents. Injustice becomes institutionalized. And eventually, people just reject the system entirely.
Okay, so that's one side of it. What's the other?
The other side is the counterbalance. If courts are corrected recklessly, They lose all authority.
Meaning if decisions can just be overturned on a whim.
Exactly. If a governor can just say, nope, I don't like that ruling, let's throw it out, then the judge has no real power. The system becomes chaotic, unstable.
So it's the ultimate constitutional tightrope walk. You have to mandate correction, but you can't allow instability.
And you have to think about the judge. How do you tell a judge who holds the authority of the state that they were wrong,
Right.
but you do it in a way that makes them a better, more careful judge next time, instead of just making them feel defensive and alienated?
Yeah.
That was the challenge.
So let's really dive into those two extremes. The source calls them the two disasters that happen when you don't have a disciplined review system. This really tells us why the structure he built looks the way it does.
Okay, so let's start with extreme one. The idea of infallible judges. This is where the whole system is geared toward protecting the ego of the court.
The ruling is final because the judge said so. End of story.
Precisely. And the consequences are, well, they're deeply corrosive. First, obvious errors, whether they're just administrative typos or huge legal misinterpretations, they become permanent.
They get baked into the system.
Exactly. An incorrect precedent gets set, and then other judges start citing it, and that one error gets replicated and compounded across the entire empire.
And the public relations side of that must be a nightmare.
Oh, absolutely. Imagine you're a litigant. You have a clear slam dunk case that the judge completely misunderstood the law, but the system's official answer is just, too bad, the ruling stands.
Public trust just evaporates.
It vanishes. People stop seeing the courts as a place to find truth and start seeing them as just another tool of arbitrary power. Injustice isn't a mistake anymore, it's a policy.
Okay, but then the pendulum can swing too far the other way.
Right, and that brings us to extreme two, chaotic reversal.
This is where appeals are too easy.
Too easy, unstructured, or worse, manipulated by outside forces, where just being unhappy with the outcome is enough to trigger a full-scale reversal by some higher authority.
So what does that lead to?
Judicial paralysis.
Yeah.
Total paralysis. If every single decision you make can be instantly and endlessly challenged, then as a judge you start to realize your rulings don't actually mean anything. They have no weight.
Why bother spending months on a complex case if a politician can just throw it all out?
Exactly. It completely undermines the coherence of the law itself. A legal decision that isn't final isn't really a decision. It's just
An expensive opinion.
an expensive, time-consuming advisory opinion.
Yeah.
It destroys certainty, and certainty is one of the most important things the law is supposed to provide for society.
So Umar saw both of these threats. He wasn't just thinking about one trial. He was thinking about the long-term stability of the entire judiciary across a massive, expanding empire.
Yes. And he realized the correction of error had to be structured. It had to be based in law, and it had to be respectful. It had to serve stability, not undermine it.
It had to be a constitutional solution.
Not just a quick administrative patch. And that philosophical rejection of both extremes is what makes the structure he built so brilliant.
So let's get into that structure, the practical solution. The core principle that Umar established was, for its time, completely revolutionary.
It really was.
And the principle was this: a court that corrects itself strengthens justice.
That mindset shift is just profound. Under this framework, an appeal isn't an embarrassing failure. It's not a black mark on a judge's record.
It's a sign of a healthy system.
It's a sign of constitutional strength, of transparency and confidence. The judge being reviewed isn't seen as an enemy. They're part of a shared mechanism that's all dedicated to one thing: upholding the law.
So the goal of the appeal was to protect the person who might have been wronged and to protect the integrity of the law itself.
And never to humiliate or punish the individual judge.
This is why the sources describe it as a constitutional safety valve. It's not a political weapon for a governor to overturn a ruling they don't like.
No, it's a controlled, institutional way to release the pressure that builds up from a potential injustice. You release it through the valve instead of letting it build up until the whole system explodes.
And a safety valve has to be calibrated perfectly, not too loose, not too tight.
That's the key. And to get that precision, the appeal system had these incredibly disciplined, formal rules.
So let's break those down. Let's start with the most important one: the grounds for review, the why. What did it take to even get your case looked at by the caliph or a senior judge?
This is the critical bottleneck. An appeal was absolutely not granted just because you were unhappy with the outcome.
So if you lost, but the process was fair and the law was applied correctly, that was it.
That was it. Your case was closed. The grounds for review were strictly limited to clear, verifiable mistakes. legal or procedural. This was designed to stop the system from getting flooded with frivolous challenges.
And the sources lay out 4 main grounds. Right?
That's right, 4 categories of what you could call systemic failure.
Okay, what's the first one?
A clear procedural error occurred. This is all about due process. If the judge failed to follow the established, standardized rules of the court.
Give me an example.
Okay, let's say a judge in Kufa held a key hearing without one of the parties being properly notified, or they refused to allow a crucial witness to be cross-examined.
So the whole trial is tainted from the start.
It's a fundamental structural flaw. It makes the verdict unsafe, regardless of the actual facts of the case. It's grounds for review.
Okay, that makes sense. What's the second ground?
The second one focuses on evidence. Evidence was mishandled.
Meaning?
This means the judge either improperly admitted evidence that shouldn't have been allowed, like, say, hearsay or a forged document, or, the other way around, they refused to admit crucial, valid evidence that could have changed the whole outcome.
So if there was a land dispute and the judge just ignored the official authenticated deed?
And instead went with an emotional appeal or a personal feeling? Yes. That's mishandling of evidence. It's not about disagreeing with how the judge weighed the evidence. It's about proving the judge broke the established rules of what is and isn't evidence.
Okay, so we have procedural error and mishandled evidence. What's number 3?
The third is that testimony credibility was flawed. Now, this one is very nuanced, even for modern courts.
I can imagine.
It means the reviewing authority found that the original judge made a clear, serious error in judging how reliable a key witness was.
But isn't that the trial judge's whole job? To look the witness in the eye and decide if they're telling the truth?
It is, which is why this was probably a very high bar to clear.
Right.
This wasn't for cases where you just thought the judge believed the wrong person. This is likely for situations where it was discovered the judge had relied heavily on testimony from someone who was legally disqualified from testifying.
Like someone with a known conflict of interest or a history of perjury.
Exactly. It had to be a clear legal reason, not just a casual disagreement.
Okay, and the fourth and final ground?
The law was misunderstood or misapplied. This is the classic legal error. The judge either applied the wrong legal rule to the facts of the case, or they completely misinterpreted the standard jurisprudence.
Like in a complex inheritance case.
Perfect example. The rules were codified and complex. If a judge applies the wrong section of the law or just does the math wrong on the shares because they misunderstood the legal text, that is a clear misapplication of the law.
So by limiting appeals to these 4 categories, Umar basically blocked all the emotional, I just don't like it appeals from ever getting through.
It forces the person appealing to make a specific, technical, legal argument. It elevates the whole process.
That structural discipline is key, which brings us to the next point. The authority of review. The who. Who gets to tell a judge they were wrong without completely gutting their authority?
And this part is pure institutional genius, aimed right at preserving the separation of powers. Review was only done by senior judicial authorities or the caliph himself.
But the caliph was the head of state. Isn't that a conflict?
But he was acting in his capacity as the supreme judicial authority. And here's the absolute key. Governors, local political figures, military commanders, they were all explicitly excluded from reversing judgments.
That exclusion is everything.
It is. In a huge, sprawling empire. If the governor of a province could just overturn a local judge's ruling because it went against one of his friends.
The judge has no independence. They just become a puppet.
They become a rubber stamp for the local political boss. The review had to be strictly legal, not executive or political. It built an institutional firewall between the judiciary and politics.
Incredible. Okay, and the last piece of the structure, the how, the process itself.
This is all about professionalization. It was about written reasoning.
So everything had to be on paper.
Yes. The original judge's decision had to be documented, with an explanation of the ruling and references to the evidence and legal texts they used.
And if that decision was overturned?
The reversal also required a clear, formal, written legal reasoning.
So no one could just write, I disagree, and send it back?
No. You had to articulate which legal rule was violated, which procedure failed, and why the new ruling was the correct one according to established jurisprudence.
And that written record does 2 things, I assume.
At least 2. First, it holds the senior reviewing authority accountable. Their reasoning is out there for everyone to see.
So they can't be arbitrary either.
Exactly. And second, and maybe more importantly, that written reversal becomes a teaching tool. It's a new piece of precedent, a clarification of the law that is immediately circulated, training every other judge in the system. It's a continuous quality control loop.
The mechanics are fascinating, but that's only half the story. You can design a perfect system on paper, but if you terrify your judges,
You end up with a paralyzed judiciary.
you have to think about the human element. We have to talk about protecting judicial morale. If a judge is constantly afraid of being publicly humiliated or having their career ruined every time they make a ruling, they're going to become a weak judge.
They will. They'll start ruling conservatively. They'll avoid tough cases. They'll rule based on which way the political winds are blowing, not based on the law. A judge has to feel secure enough to make principled, sometimes unpopular decisions.
So the system had to be designed to be constructive, not punitive.
Yes. The source is very clear on this. The corrections process was engineered to be principled, reasoned, and respectful.
The goal was for the judge to learn, not to be broken.
It's a subtle but really vital point about institutional culture. If the caliph reviewed a case and found an error, the message back to the judge wasn't, "You're incompetent."
Right. It wasn't a personal attack.
No, it was, "The legal principle of X was misapplied here. This is the correct application according to the established texts." The focus is always on the law, on the principle, not on the judge's personal failure.
So it's a feedback loop that feels more like professional development.
That's a perfect way to describe it. You maintain the judge's dignity. They learn that making an error is acceptable as long as you learn from it. And it reinforces the idea that everyone is part of this larger self-correcting body.
Now, let's zoom out from the individual judge to the whole empire. This centralized appeal system was absolutely crucial for maintaining legal unity.
Oh, is the glue holding the whole legal system together.
You have this massive expanding state with all these different regions, different cultures, different pre-existing legal traditions.
Without a central review mechanism, you would inevitably get legal fragmentation.
What does that mean in practice?
It means a commercial contract could be interpreted one way in Medina, the capital, and a completely different contradictory way in a new province like Egypt.
And that's a recipe for chaos.
It's a recipe for economic and social instability. A trader moving across the empire needs to know that the laws governing their property and their contracts are going to be the same everywhere.
So the appeal system acted like a central clearinghouse for legal interpretation.
It did. It ensured that the law meant the same thing in Kufa as it did in Medina. If a local judge got a rule wrong, the central review corrected it, and that written correction was then circulated.
So mistakes couldn't become entrenched as local customs.
Exactly. Deviations were corrected early. It preserved legal unity. It's very similar to the role of a modern Supreme Court, which spends a lot of its time harmonizing different interpretations from lower courts.
Okay. But with any appeal system, there is always one huge risk. The risk of things never ending.
The danger of endless litigation.
Yeah.
Yes. And Umar clearly understood this. He stressed the importance of finality.
Because justice needs two things, right? It needs to be accurate, but it also needs to be over. It needs resolution.
Unlimited appeals completely destroy certainty. The parties are just trapped in a legal and financial limbo forever. The source is clear that finality wasn't a secondary goal. It was essential to the definition of justice.
So how did he enforce that? How do you have a right to appeal but also have finality?
You enforce it through those structural limits we talked about. Because the grounds for review were so narrow, only legal or procedural error, it stopped people from just endlessly re-arguing the facts.
The bottleneck.
The bottleneck. And once a case was reviewed and a final reasoned ruling was issued by that senior authority, that was it. The system enforced closure. The case was settled.
And that structure seems almost purpose-built to deal with another chronic problem in legal systems, preventing abuse by the powerful.
Yes. Historically, and even today, appeal mechanisms are often weaponized by the elite. They use endless litigation to delay justice or harass opponents who have fewer resources. They don't need to win the case. They just need to make sure it never ends, to bleed their opponent dry.
The legal system as a weapon of attrition.
Precisely. And Umar's system blocked this in a few ways. First, again, those strict grounds for review. You couldn't just appeal because you could afford a better lawyer to re-argue everything.
Second,
The controlled authority. The decision to review and reverse was taken away from local political figures who could be pressured by local elites and put in the hands of a central legal authority who demanded a rigorous written justification.
and there was a third element, a moral one.
Yes, an element of moral accountability. The whole system was designed to feel serious and difficult to use frivolously. It wasn't something you entered into lightly. This served as a powerful deterrent against using appeals just to harass the poor or the weak.
The system basically said, if you have a genuine legal grievance, we will hear you. But if you're just trying to play games...
This is not the system for you.
So in the end, the real test of a judicial system is what the people it serves. Think of it. Let's talk about building public confidence.
Right. For the ordinary person, the litigant, what did all this actually mean for them?
What did it provide?
It provided, I think, something absolutely fundamental. Hope against injustice. They knew their local judge was a human being who could make a mistake. But they also knew that the system itself wasn't a rigid, unfeeling machine. If they could show a real legal error had occurred, there was a higher independent path to get it corrected.
And that builds trust. It builds confidence in the fairness of the system as a whole.
It does. You might still lose your case, but if you believe the process was fair, the rules were followed, and there was a mechanism to check for mistakes, you're much more likely to accept the outcome.
The system earns its legitimacy.
It earns its legitimacy through its transparent, reliable internal quality control, not by pretending to have perfect judges. It transforms a ruling from just an act of power into an act of disciplined law.
Now, let's do some comparative constitutional insight. When we look at this 7th century system, the parallels to the modern world are they're striking.
They really are. The basic principle that Umar established is the foundation of modern appellate law.
Our appellate courts and Supreme Courts today, they generally do the same thing. They don't retry the facts of the case.
No, they restrict their review to errors of law, errors of procedure. They audit the process.
We see it in things like review petitions, where you ask a higher court to look again at a decision because of a demonstrable legal mistake.
Or in writ jurisdictions and common law systems, where a superior court can step in to correct a grave injustice from a lower court. It's the same idea. A restricted legal review to ensure uniformity and justice.
It's a clear lineage of legal thinking.
Absolutely.
However, the source also offers a pretty sharp critique of modern systems. We have the same basic structure, but we often fail spectacularly in the execution.
And this is where the historical example becomes a real challenge to us today. The biggest failure in modern systems is, without a doubt, crippling delay.
An appeal can take years, decades even.
And that delay isn't just an inconvenience, it's an active denial of justice. Justice delayed is justice denied is not just a slogan, it's a reality. The cost and the time involved mean that the powerful can often just outlast their opponents.
The second major problem, politicization.
In so many countries, appointments to the highest courts and the decisions they make are viewed through a purely partisan political lens.
Which is exactly what Umar tried to prevent by taking reversal power away from governors.
Exactly. When the public starts to believe that the highest court is just another political player, the moral authority of the entire judiciary just collapses.
And the third, modern failure.
Procedural abuse. The sheer complexity of our modern legal rules, which were ironically designed to ensure fairness, can now be used as a weapon.
How?
Wealthy litigants, big corporations. They can use their resources to file endless motions, exploit tiny technicalities, and basically use the procedural maze to grind their opponents into submission.
It's a nightmare scenario.
It is. And it's a direct contrast to Umar's system, which the sources describe as lean, moral, and principled. It was efficient because it prioritized legal substance over procedural games, and it was guarded by that strong moral accountability from the very top.
So this is where we can really distill the lessons for today. Given that so many countries are facing this crisis of delayed, uncertain justice, what are the core principles we can pull from 637 CE?
I think there are 5 foundational lessons.
Okay, let's hear them.
First, appeals must be structured. No ad hoc interventions. You need clear, established rules and paths.
Second, grounds must be limited. That's the bottleneck. We have to focus review on demonstrable legal or procedural error, not just retrying cases forever.
Third, and this is non-negotiable, authority must be legal, not political. The independence of the appellate body has to be sacred.
Fourth, the human element again. The dignity of judges must be preserved. The correction process has to be professional and educational, not a tool for intimidation.
And finally, number 5, finality must exist. Justice demands resolution. Once the highest review has happened and a reasoned ruling has been issued, that has to be the end.
These 5 principles, they really seem universal.
They are. They represent universal constitutional wisdom on how to manage human imperfection within a system that still needs to command authority. The integrity of the system rests not on the brilliance of any one judge, but on the wisdom of the structure that guides and corrects them. So, to leave you with a final reflection on all this,
Yeah.
what we see in Case 15 is that Hazrat Umar was not afraid of admitting error.
No, he wasn't.
He was afraid of one thing above all else: uncorrected injustice. And he solved that constitutional paradox by institutionalizing a reliable, reasoned way to find and fix mistakes.
And in doing that, he managed to achieve 3 critical goals all at once.
He did. The law stayed coherent and uniform across a vast empire.
The judges remained respected, professional authorities.
And the public, the ordinary person, remained protected from the permanent consequences of a single human mistake.
A system that can correct itself is a system that can endure.
That's the ultimate takeaway. That is foundational constitutional law.
And that principle, established nearly 14 centuries ago, is such a powerful reminder for us today that real lasting authority doesn't come from pretending to be infallible. It comes from demonstrating transparent, principled, and reliable accountability.
A powerful thought indeed.
And speaking of accountability, next time, we're shifting the focus. We're moving from disputes between citizens to something even more challenging.
That's right. Disputes between citizens and the state itself.
So please join us for our next deep dive, Administrative Court Jurisdiction, Case 16, Holding the State Itself Accountable.
We'll be exploring how Umar created a mechanism for citizens to actually challenge the government and its actions, expanding the definition of justice into the public sphere. It's going to be fascinating.
We look forward to having you with us. And if you enjoyed this discussion, please do subscribe to our channel, like this video, and share it with your friends. It really helps us continue these deep dives. Thank you for listening.